Thank you again for joining us. This is Sexual Harassment in Oregon K through 12 Schools, Part 1. We're going to talk today about the new Title IX regulations. I hope you all will join us on Thursday for Part 2, where we're going to go a little bit more in depth into some of the pieces today. We've got an hour together this morning, and so let's jump right in because there's a lot of information to cover. So my name is Kate Hildebrandt. I use she, her pronouns. I'm the Civil Rights and Title IX Specialist at the Oregon Department of Education. You can contact me here, and I'll post my contact information at the end of the webinar as well. It's really great to meet a lot of you for the first time remotely, as a lot of us shift to remote work recently. And I'm excited to keep working with you and supporting all of you in implementing these new regulations over the next couple of months. So this webinar is being presented by the Oregon Department of Education. Our goal is to support students, their families, and districts in educating all of our students in the public education system. Our goal is that all students will be able to achieve success and to go on post-graduation to achieve whatever their goals are. A big piece of that for us is our education equity stance, where we really believe that it's important to look at our education system through the lens of equity. And that includes thinking about how our policies, our practices, and our procedures impact historically and currently marginalized students, youth, and families. And I think that's really important when we're thinking about the current Title IX regulations and how this might be disproportionately impacting some of our students. So we're going to look at these regulations today through this lens and think about how we can implement them with thinking about equity. A few more things before we dive into the regulations. One, I just want to be clear that this webinar is not completely exhaustive of the new regulations and requirements. When these were released, they were also released with about a 2,000-page preamble, which has a lot of additional information. And while we're going to be diving into a lot of this in the biggest stuff, please know that there are also going to be some additional things. We'll cover some of those on Thursday, but there will be other things that you'll need to attend to as well. We also want you to know this webinar is not intended as legal advice, and we absolutely advise you to consult with your legal counsel before making policy or process changes. We also want you to know that ODE is available to support you with technical assistance and training following these webinars. And again, you can contact me, and I'll post my email address up at the end for more information about how you can get access to training or if you have specific questions. So today we're going to be talking about a couple things. First, we're going to go very briefly over the history of sexual harassment in Title IX. Then we're going to talk about some of the big changes. We'll cover the biggest ones, and again, we'll follow this up with Thursday talking about some more of them. And then today we're going to look at a step-by-step process of what the new grievance process is going to look like under the regulations. So what will happen from the time when you get a report of sexual harassment at your school all the way up through the investigation, adjudication, and remedies process. So let's start off and talk very briefly about a history of Title IX and sexual harassment. As we dive into this, I also want you to know I'm going to be using a lot of terms that the regulations use specifically. For example, they use the term complainant when they're talking about a person who reports experiencing sexual harassment, and they use the term respondent when for the person who is reported to have committed the sexual harassment. You can find all of these terms in the terminology list, and that goes through some of the more common terms that are used both in the regulations and just in this work more generally. So this is the language of Title IX. Title IX was passed in 1972 as part of the education amendments that year. And it basically says that no person shall be subject to sex discrimination in public education. It's, as you can see, a very short piece of information. There's obviously a lot more that goes into it, and it touches on a lot of pieces of our K through 12 education system. You can see just a few of them down here. I think the most common one we've historically associated with Title IX is athletics, and often in the past, our Title IX coordinators in the K through 12 world have often been our athletic directors or other folks in that area. But as you can see, it touches on a lot of things. The regulations that came out this past May specifically focus on sexual harassment. And so that's what we're going to be talking about today. But just know that if you're the Title IX coordinator, of course, your role touches on a lot more things than just sexual harassment. So let's look briefly at the history of Title IX, specifically with sexual harassment, just so we can understand how we got here. So Title IX passed in 1972. And again, when it was first passed, it was really specifically focusing on the larger area of sex discrimination. And some of the first instances that it was used were around athletics, which is how it got the reputation of Title IX being pertaining mostly to athletics. In the 1980s, however, there were some court cases where the Supreme Court said, yes, sexual harassment is a form of sex discrimination, and they specifically applied it to that. And so since then, it's been widely understood that Title IX includes sexual harassment. Fast forward a couple of years, and we get our first major piece of guidance from the U.S. Department of Education's Office of Civil Rights, who administer Title IX for education programs, that tells schools what they need to do specifically related to sexual harassment. This was first published in 1997 and then was revised slightly in 2001 after a couple of court cases came out. But it's called the 2001 Sexual Harassment Guidance, and this is largely what we've used in the past several years or really the past 2 decades when we're responding to sexual harassment. Fast forward another couple of years, and we get another really significant piece of guidance. In 2011, the U.S. Department of Education released a Dear Colleague letter that specifically spoke to sexual assault or sexual violence and gave schools some additional things that they needed to focus on and do related to sexual harassment. They were specifically very clear: sexual assault, sexual violence are a piece of sexual harassment. They reiterated a lot of things from the 2001 guidance and expanded on a couple of things. This really entered us into a new era of focus on sexual harassment. And in the years following this, we saw a real ramp up of complaints submitted to the U.S. Department of Education about sexual harassment and sexual assault, especially in the higher ed world, as well as OCR, the Office of Civil Rights, taking on those complaints. This was followed up with a couple of other pieces of guidance, such as a piece of guidance in 2014 and some other things that OCR did. Now fast forward again, and so we have this 2011-2014 guidance, and then in 2016 we have an election, and that changes the administration, which also changes the Secretary of Education and a little bit of the focus of the U.S. Department of Education. So in 2017, the new Secretary of Education, Betsy DeVos, announced that they were going to be revoking that 2011 and 2014 guidance, and they were intending to replace it with regulations. Regulations, of course, having a little bit more force than just guidance. A little over a year later, we finally got a draft of those regulations. In November 2018, those were released, and that draft really previewed that there were going to be some major changes to sexual harassment processes. These guidelines really had a focus on due process and on a lot of very specific things that needed to happen in the grievance process, and made a lot of changes that were changing how things had been handled both on the higher ed level and the K through 12 level. Slightly different from this regulations process, but really parallel to it. In February of this year, we got an announcement from the Office of Civil Rights that they were really going to be taking a harder look at sexual harassment in the K through 12 context, specifically of students by employees. The past decade has really been marked with a lot of public attention on higher education when it comes to Title IX. There's been a lot of news stories, a lot of things like that. And this was an announcement from OCR that they were going to be turning a lens and looking specifically proactively at K through 12. That's really important for us to know, especially as we think about implementing the new regulations in the coming months. So November 2018, that's when we got the draft. People submitted comments, they made suggestions, we thought about what this might mean, but it wasn't until May 6th of this year, so about a year and a half later, that we got the final regulations. And now we know that those will be implemented and will be required to comply with them by August 14th. I put an asterisk there because there have been a couple of lawsuits that have been submitted around these regulations and specifically around the deadline. but until we hear otherwise, we need to assume that August 14th is going to be our compliance deadline and plan to be in compliance by then. All right, so let's look at what's changed under the new regulations. And just to reiterate, I'm getting a couple additional comments. Folks are still having trouble downloading these slides PDF, so I'll be sending an email with those, with the PDF in that immediately following this webinar. So here's some of the major changes that we got in Title IX in the new regulations. We got a new definition of sexual harassment. We got a new definition of what the scope of our jurisdiction, where and how the complaints that happen and what we have to respond to. We also got some additional requirements around supportive measures and notification of options. We got a new and really specific grievance process, as well as new policy requirements around that. More specific notification requirements, specific training and personnel requirements, as well as the allowance of informal processes in all cases. So we're going to be talking about some of these today, and then the highlighted portions we'll really dive into a little bit more on Thursday. So come back on Thursday, same time, 9 a.m., if you're interested in diving a little bit more into those. Just as important as what is different is what's the same. There are a lot of things that are not changing with these new regulations. One of those, students are still entitled to an education free from sexual harassment, and schools still need to respond when they hear that students or employees are experiencing sexual harassment. Another thing that's the same, all K through 12 school employees must report sexual harassment when they hear about it. You might have heard some things in the news that employees are no longer required to report, but that's on the higher ed level. On the higher ed level, they've changed the requirements of employees, but for K through 12 schools, they're very explicit. All employees still must report sexual harassment to the Title IX coordinator when they know about it. Another thing that's the same, schools still need to have a designated Title IX coordinator and make that information easily accessible through the website, published in handbooks, and they list out some specific requirements. We'll go through those more on Thursday. Another thing that's the same is that complainants and respondents can still have an advisor of choice throughout the process. This has been something that's been talked about in previous guidance documents, talked about extensively in the 2011 and 2014 guidance documents, and it's now part of these official regulations that you have to allow them to have an advisor, to come with them to meetings, to interviews, things like that. The other thing that's the same is that Oregon laws are still going to apply. Oregon has a lot of specific laws around sexual harassment. We have sexual harassment policy requirements. We also have a lot of intersecting laws like SB 155, our sexual abuse and sexual conduct law, mandatory reporting. A lot of those things are going to overlap with Title IX sexual harassment. What the Title IX regulations say is that where there is a direct conflict between those regulations and any state laws, the regulations will take precedence. However, the Title IX regulations for many things create more of a floor and not a ceiling. So while the Title IX definition of sexual harassment is different than the Oregon definition, schools are still required to adhere to Oregon state law with that definition. And we'll talk more about what that looks like. So let's look at what some of these new big changes are. First one, sexual harassment. So sexual harassment in the new regulations has a three-pronged definition. The first one is quid pro quo sexual harassment. And this is a very traditional, really pulled from employment law definition of sexual harassment. It's the I'll do this if you do this definition. And so if you're seeing things where an employee, a teacher is conditioning a grade or getting into a class on some sort of sexual favor, that's going to fall under quid pro quo harassment. The second one is where we see a big change, prong 2. This is unwelcome conduct that is severe, pervasive, and objectively offensive. That "and" term is pretty different from what we've seen in the past. And in the past, you've probably heard that it's been severe, pervasive, or objectively offensive. And those are the things that we typically use in our Oregon and our state statutes as well. So this "and" is a big change for Title IX. And also that it has to effectively deny a person equal access to the recipient's education program or activity. This is going to be a big shift for schools in looking at, does the thing that's reported hit that severe, pervasive, and objectively offensive standard? This is sometimes called the Davis standard because it's pulled directly from a Supreme Court case from about 2 decades ago around Title IX liability. So that's a different one. One important thing to note is that severe, pervasive, and objectively offensive only applies to conduct under prong 2, so it doesn't apply to quid pro quo harassment or this prong 3 definition that we'll talk about in a minute. So the third one, prong 3, includes sexual assault, domestic violence, dating violence, and stalking in the definition of sexual harassment. We're very used to considering sexual assault, but domestic violence, dating violence, and stalking may not have always been in our sexual harassment policies on the K through 12 level. So this will be a slightly new thing for us as well, or for many of us, I should say. These definitions for the regulations are pulled from the Clery Act, which is a higher education act around crime reporting, but it uses those definitions. Those are included in your terminology handout, so you should have those and be able to look at what those look like. Their definition of sexual assault is pulled from the FBI Uniform Crime Reporting Code, so it includes sexual assault as a broader term that includes a bunch of specific things, including, for example, forcible rape, but also fondling and some other aspects as well, and those are detailed in your handout. The definitions of domestic violence, dating violence, and stalking are pulled from the Violence Against Women Act amendments to the Clery Act, so those what those come from in your terminology handout. The second change to go over is the scope of jurisdiction. So what are schools required to respond to under Title IX when they hear about a complaint of sexual harassment? So for the new Title IX regulations, they're specific that 1, it must occur within the United States. And that's because they're going off that original text of Title IX that says no person in the United States. This is not going to be a huge deal for us on the K through 12 level. However, if you have school trips to, up to Vancouver, British Columbia, or you do take students on international trips, know that that's going to be a limit to what's considered within your educational program or activity in the United States. The other thing they limit us to is that we're required to respond to sexual harassment that occurs within the scope of an education program or activity. And they define it here for us as locations, events, or circumstances over which the recipient exercised substantial control over both the respondent and the context in which the sexual harassment occurred. So we get this very specific definition. They're clear that this isn't limited to just things that happen on a campus. So it's not just in the classroom or inside a school building. It could be at an athletic program, on a bus to and from school. It could also be at a fundraising event that's hosted by a restaurant, but that's a school-sponsored program or activity. So thinking about what's within the scope of your educational program or activities is really important for understanding. Now, again, I think it's important to emphasize here that this is for the purpose of Title IX sexual harassment. Again, remember that you are still required to adhere to Oregon law, which mandates response beyond this. So while Title IX limits you to these, if there's other laws in your state, such as in Oregon, that do say you need to respond to a broader definition of this, then you still need to be doing that. Another change we have is this putting in the regulations directly this idea of supportive measures, or what we often call safety planning in the K through 12 world. And this is something that we've been doing for a long time. When we hear that a student or an employee, someone has experienced sexual harassment, we often put in a safety plan for them, or we put in supportive measures. But the new regulations actually put this into the text of the regulations. So they say that anytime a school has actual notice of potential sexual harassment, and remember, in the K through 12 world, that's notice to any employee, then the Title IX coordinator needs to reach out to the person who experienced it and discuss the availability of supportive measures and come up with a plan for what can support them. They'll also need to explain the process for filing a complaint so that person knows that they can if they choose to do so. In the regulations, supportive measures are specifically defined. So they're non-disciplinary, non-punitive, individualized services, and their goal is to restore or preserve educational access. And here's an important part of this, without unreasonably burdening the other party. So they give us some examples in the discussion preamble to the regulations of what this could include: counseling, extension of deadlines, modification of class schedules, changes in work locations, leaves of absence. These are not exhaustive. These are just a couple of common examples. Now, this important part of unreasonably burdening. The regulations are clear. That doesn't mean that it needs to have absolutely no burden or impact. It just can't unreasonably burden the respondent or the other party in a way that might impact their equal access to education. So let's think about an example. If you have a student who is in an English class with a person who sexually harasses them, and that student, who would be called the complainant under these regulations, says, I don't want to file a report, I just want to be in a different class. You could move the complainant to a different English class. You also could move the respondent potentially to a different English class if it wouldn't impact their education in any other way. So if you had, for example, another English class that you could just switch two classes out, they'd be in the same classes for those two switched ones. It wouldn't impact their education, wouldn't impact their grades. Those two classes are on the same learning tracks. Then that would be something that probably wouldn't unreasonably burden them. However, similar example, but let's say you have a school where the two students are in AP Calculus and there's only one section of AP Calculus. And if you were to remove one student from AP Calculus, they would have to go to a pre-calculus class or have to drop math for the year. That would be something that would unreasonably burden the other party. And so the supportive measure you could make in that instance would only be one where you could either remove the complainant in that case, or you could, for example, give them distance learning or other accommodation requirements. They're also clear that supportive measures are not necessarily just for complainants. They also should be offered to respondents as well. They're for any students or employees, any individuals involved in these who might need support around sexual harassment. The new regulations also require very specific grievance processes. So anytime that a school receives a formal complaint, they go through very specific steps that a school must take, and we're going to look through those in just a moment. So they require these specific steps, also very specific policy components, including timelines, standards of evidence. You have to list the range of supportive measures, of sanctions, all kinds of stuff like that. They're also very clear that no sanctions or disciplinary action can be levied against a respondent until the conclusion of a grievance process. Which brings us to a question that I very commonly get when we talk about that. What about interim suspensions or administrative leave? If I can't levy any disciplinary action, can I interimly suspend a student? Can I put someone on administrative leave during the case? And the answer is yes. The regulations do allow you to do those two things. So emergency removal of a student, and they call it emergency removal as opposed to interim suspension, is allowed following a risk analysis and provided that the respondent who's been removed is provided with immediate notice and immediate opportunity to challenge that removal. So that's the due process piece that they put into that immediate removal. They need to be notified about it. They need to have an opportunity to challenge it. The regulations are also clear that any emergency removal must comply with 504 and IDEA requirements. So if a student has an IEP or a 504 plan, if an employee has ADA accommodations, those need to be complied with. The second thing is administrative leave of employees, and that is allowed either paid or unpaid. So you can look to what are your current practices, what other state laws require, and that's if a grievance process is pending. So that's important for us to know here in Oregon because we do have state laws around administrative leave relating to sexual harassment or behaviors that could constitute that. Specifically, SB 155, our sexual conduct law, which went into effect this year, requires administrative leave in certain instances related to sexual conduct and sexual abuse. So know that that is still going to be allowed under these regulations, and you'll need to work to marry these two processes and make sure you're adhering to both. Another big change is the allowance of informal processes across the board. Informal processes have been allowed previously under Title IX, but they've been strongly discouraged for things such as especially sexual assault or when there's kind of more severe cases or big power differences. So now the regulations say you can use an informal process. It's an option you can offer in any instance except employee on student sexual harassment. For student on student, for employee on employee sexual harassment, you can offer the option of an informal process. You're not required to offer this option, so know that if your school doesn't have the infrastructure to support that, you don't have to have that in place. But it is a good option that you can think about doing to offer to your students. A couple of things must happen. So first, a formal complaint must be filed. Notice must be given, which can include informal process information. And you also must tell people who are opting into the informal process, this is how you can opt back in to the formal process. And this is where in the informal process, you might not be able to do that anymore. So there may be, for example, a piece in your informal process where once you have come to a mutual decision and everyone has agreed, these are the sanctions and remedies, you're going to say, okay, once that decision has been made, you can no longer opt back into the formal process. You just need to very clearly outline that and explain that to parties going ahead. Both parties must also submit written consent to be a part of the informal process. And there can't be any pressure to participate in it. It can't be a condition of returning to school or returning to employment. It has to be a completely voluntary process. And again, folks could decide that they want to opt out of that and go back into the formal process throughout. All right. So let's take a look at the grievance process under the new Title IX regulations. Oh, and I did get a question here, and I forgot to say this at the beginning, but please feel free to submit questions. I'll try to get to as many as I can as we go, and then more at the end. But the question was, can you give an example of when someone would want to engage in the informal process? Let me go back to that slide. So a student might want to engage in an informal process if, for example, and I think this is actually very common with survivors of sexual harassment, of sexual assault, that someone might say, you know, I don't necessarily want to get this person kicked out. I just want them to be held accountable for what happened. The thing that I'm really looking for is for them to not be in my classes anymore, and I want them to complete some counseling sessions, for example. And so that's something where you could have a formal process to go through, or they could say, I'm really open to just having some discussions with this person about what happened, the impact it had on me, and what I would like them to do. An informal process might be appealing to a respondent because it wouldn't necessarily, maybe it wouldn't go on their disciplinary record in the same way. They might feel that it's more hopeful that they could get maybe something that wouldn't result in suspension or expulsion, especially if they're afraid of that, although that could result from an informal process. Sometimes we also do get respondents. It may feel rare, but some respondents are willing to admit, yeah, you know, I messed up and I want to take accountability for what happened. I've seen that happen, as rare as it sounds. So there may be times when an informal process may be appealing to both parties for a variety of reasons. All right, so let's look at the grievance process under the new regulations. We're going to walk through step by step what the new regulations require and what this might look like in practice. So in the new regulations, we've got these 6 steps that you would go through in pretty much any process. An appeal might not happen in every process, but with the exception of that, you're going to go through everything every time. So step 1, actual knowledge. So actual knowledge is when a school knows about possible sexual harassment. And remember, for K through 12 schools, actual knowledge includes notice to any school or district employee. So a teacher, a janitor, a coach, anyone who gets knowledge that there might have been sexual harassment going on. They need to report that to the Title IX coordinator so that we can then implement our required actions. Once a school has actual knowledge, they're required to respond in a way that the regulations call not deliberately indifferent. They give us some specific things we need to do. So for example, that includes contacting the complainant, making an outreach to them, offering them supportive measures, and describing the process for filing a formal complaint. So those are 3 things that you need to do every time you have actual notice. There also are potentially other steps that you might need to take, and those are things that the school might need to do in order to not be deliberately indifferent. This is going to vary case to case. In many cases, it's not going to be anything beyond these 3 things, but in some cases, And let's say, for example, you're getting multiple reports of actual notice of an ongoing environment where, for example, students are sending around sexual photos. And maybe you don't actually have a ton of information about what's in the photos or who is saying them, but you're getting information about this. This is happening a lot. You might want to do some other things to not be deliberately indifferent. And so that could be, we're going to implement more education programs. We're going to bring in some folks to do some awareness activities next year. And so you're documenting that as, in addition to contacting the known complainants and describing this, we also implemented some educational programming because we felt we needed to do that in order to respond to this known environment going on at our school. Another important point, there's some intersections of specific Oregon laws I wanted to point out for all of you. So once we have actual knowledge, a couple of other things could come into place. One of those is our Notice of Rights and Options document. This is from HB 4150, which is from 2018, but it's one of our requirements for our minimum requirements of sexual harassment policies in Oregon schools. This is a document that describes to individuals how to report, what some options are for reporting and support measures, both offered by the school, but also with local law enforcement and community-based agencies, as well as additional resources. So whenever you have actual knowledge, this is going to trigger you, I need to give my Notice of Rights and Options document as well to the complainant or to the reporting person. This also may implicate mandatory reporting requirements or SB 155 sexual conduct requirements. And that is some additional reporting, and that's going to specifically be when it is employee on student harassment. So step 2, formal complaint. So again, actual knowledge doesn't mean you are triggering the grievance process. That means you need to reach out and let them know about options to file a formal complaint. But the only way the grievance process is triggered is if there is a formal complaint. And that's defined as a document submitted by the complainant or signed by the Title IX coordinator requesting the initiation of grievance procedures. Now, in the K through 12 world, where we are dealing with students who are under the age of 18, a document submitted by the complainant could also be submitted by their parents. So for K through 12, that's going to be technically 3 people that could initiate grievance procedures: a complainant, one of their parents, or the Title IX coordinator. The regulations really emphasize that we need to consider the wishes of the complainant in this case, and it's important to not just blindly move forward if the complainant doesn't want us to. However, there might be some cases where the Title IX coordinator would be signing a complaint and moving something forward without the complainant or without a complainant. And I'm sure we can all think of a couple examples of that. One of those might be, for example, if you're getting several instances of actual notice of sexual assault by the same respondent, and especially if you feel that you have evidence and support to move a complaint forward, even if the complainants do not necessarily want to participate. That could be an instance where the Title IX coordinator might sign and initiate a grievance process because they feel they need to do that to not be deliberately indifferent. And that's really the space they're leaving open here, that if a school feels that they need to initiate a grievance procedure to not be deliberately indifferent, even if the complainant doesn't want to, they're leaving you that option. But again, they're really emphasizing that it's important to involve the complainant and to take their wishes into account. And so even if you are choosing to move a complaint forward, having a really frank conversation with the complainant and figuring out what supportive measures they might need is still very important. Another thing important to do here is that under the Title IX regulations, they emphasize that if the conduct in the formal complaint does not constitute sexual harassment or did not happen in the educational program or activity of the school in the U.S., it must be dismissed under Title IX. And again, this is under Title IX. If you have a school process or a state mandate that defines sexual harassment more broadly than these Title IX regulations do, you can still investigate it and adjudicate it under that process. It just might not necessarily be under the Title IX process. Remember that Oregon does have these mandates. We have a larger definition of sexual harassment that schools are required to use, so schools will need to think about how they're going to integrate these policies. The regulations give us 2 options when thinking about that. So the first one, they give us the option of using the Title IX grievance procedures to adjudicate cases of sexual harassment or even other things outside of sexual harassment that don't fall under that Title IX definition. So option one would be that we have a complaint submitted. We screen it for whether it meets Title IX sexual harassment, and if not, then if it meets Oregon or our district's definition of sexual harassment. And then if it meets one of those, we use the same process. So that could be option one, in which you'd have one process for all reports of sexual harassment. Option two is that a complaint submitted, you screen it for whether it's Title IX sexual harassment, and then if not, whether it's Oregon or district sexual harassment. And then depending on which one it falls under, you would initiate different grievance procedures. And so you would have these two parallel processes that might be running for different definitions of sexual harassment. So for example, let's say you have some conduct that is reported by a complainant and it doesn't quite meet the severe, pervasive, and objectively offensive standard. For example, maybe it's severe, but you don't feel it meets your school's definitions of pervasive and objectively offensive. Well, that wouldn't necessarily fall under the Title IX guidance, but it would fall under Oregon's because we have the or, not the and. So then you could institute your school-based procedures in that case, even though Title IX wouldn't be implicated. This also brings up a question of third-party complaints. So in some of our schools, third parties or anonymous complaints may be able to be submitted. So where do these fall under the new regulations? The third-party complaints would still be considered actual notice. So if you get anonymous complaint or you get a third party telling you, I witnessed this, I saw Jack sexually harassing Jason, for example, then that would still be trigger actual notice, and you would need to reach out to Jason and talk to him about his options. However, a third party wouldn't be able to file formal complaint on behalf of that person, unless of course the third party is the parent of a minor student, and then they technically could. So a little bit of a distinction there, but it's going to be a different process for Title IX formal complaints. So third parties, again, can give you actual notice, could not submit a formal complaint. However, remember that the Title IX coordinator can sign a complaint. So if you're getting third-party information and you feel that your school does need to initiate a grievance process to not be deliberately indifferent, you could have the Title IX coordinator initiate that process without the complainant. So the next step is going to be our investigation. So our investigation is always going to include interviews with parties and witnesses. You may or may not have witnesses, but you're definitely going to want to talk to the parties involved, maybe multiple interviews. An important thing to remember here is the right to bring an advisor of choice. You're also going to collect and review evidence. Evidence can be a wide variety of things. It could be emails, text messages, security video. You could have your IT department be pulling email records, for example. Lots of different things can be going on here. It's also going to include writing an investigative report. And they don't give us a specific format for the investigative report, but we'll talk about some options of that in the training on Thursday. So school districts need to set specific investigation steps, processes, and timelines in their policies. Let's take a look at a potential timeline, especially given the timelines given to us in the regulations. This is something that's going to be a big change for a lot of us in K through 12. There are some really specific timeline requirements given in the regulations related to investigations. So this is a possible timeline that I put together. Your timelines are going to be different. They're going to be based on your policies as well as vary a little bit case to case within the ranges that you list in the policies. So the bolded timeframes are the ones that are specified directly in the regulations, and I'll talk through those as we go. So the first thing that happens, you're going to get notice. And so once you have a formal complaint, you're going to send out a notice of allegations document to the complainant and the respondent. You're also going to send out, if you already know about any witnesses, notice to them that you want to talk to them. The regulations specify that you need to give quote unquote sufficient time for them to prepare for those meetings. Sufficient time is a little bit of a non-defined construct of time. It could be a couple days. What you'll need to do is set that in your policies. So you could say this is going to be at minimum 3, at minimum 5. You're going to set X number of days of what sufficient time to prepare will. If a party requests, you might meet with them sooner, but you need to make them aware of their right to have sufficient time to prepare. So let's say you send out the notice and you give them a couple of days and you set up interviews. So then on this possible just template timeline, you have days 3 to 6, you might conduct interviews and collect evidence. So in the K through 12 world, because we typically have a lot of control over our students as well as our employees, these interviews might be able to happen pretty quickly. We can call people in, pull people from class, pull people from work for a minute to talk to them, and might be able to even re-pull them very quickly. However, some investigations are going to take a lot longer, especially if you need to re-interview people, if you're taking time to collect evidence. There may be times where a party says, hey, I need more time to prepare, especially if they are out with injuries for any reason. If they want their parent to be present and that person's not available, because remember, they're allowed to have an advisor of choice. So they could bring a parent, they could bring a lawyer, they could bring really anyone they want. There are no limits on who that advisor can be. And you need to allow them to have that timeline. So let's say you conduct that in a couple of days. Day 7, you're going to send evidence and draft responses to parties and their advisors. And this is one of those mandated timelines. You must allow them 10 days to review the evidence and submit a response to it. So all the evidence that's collected, and that's directly related evidence, there's some nuances here as to what kind of evidence you are required to send, but you need to send that to both parties or all parties. And then you need to allow them 10 days for that party and their advisors to review it, to respond, and to write a written response. So they could say, hey, this piece of evidence is incomplete. I actually have the rest of the text messages, or there's context here you need to know about. So you need to give them time to respond to that. And then you need to take that into account in your final investigative report. So you allow them those 10 days to respond, and once you get that back, you finalize your investigative report. Then we get into a second 10-day timeline. So once you finalize the investigative report, you submit it back to the complainant and the respondent, and they need 10 days to review it before the decision-making process. So there are these 10-day timelines. And that's why you might have heard some people say that it's a minimum 20-day process because you have these. In reality, it's going to be more than 20 days because for many of us, if we have other things going on, these cases need to be a priority, but you might not be able to do everything you need to do in one day for every case. So then let's say you give them those 10 days. On day 28, the decision-making process starts. We'll talk a little bit about what that looks like in a minute. And then let's say you take a couple days for that process, the determination of responsibility is issued. So in this process, this is a tentative 30-day timeline. This is not necessarily a suggested timeline. Again, strongly suggest you consult with your legal counsel, make a decision as a district as to what's going to be accessible and best for you and your students. You will need to designate timelines, but you can include ranges or minimums in there. So I got a couple of questions about this. One is this work days, calendar days, business days? And the answer is that's up to you. The regulations give you the ability to designate that. You just need to say so in your policy. So you can say 5 business days, 5 working days, not including holidays, or you can say 5 calendar days. You just need to be prepared to stick to whatever you say. So if you say 5 calendar days, know that if that happens over a holiday, you're going to still have to stick to your process. Yeah, and so that includes, the question was also referencing what if something is initiated in June and students and employees are about to be off for a couple months. That is something you need to consider when you're writing these timelines for your policies. So think about, do you want to designate business days, and what does a business day mean for your district? Do you want to designate school days? Know that that also might put you into a situation where you could have these things trailing out for a couple months, and that's not necessarily a prompt and equitable response. Because if someone submits something on the last day of school and then they don't have an interview until September, that might be violating some of their rights in Title IX to a prompt, equitable response of due process. So a lot of important nuances to think about when you're designating your policies, because these policies are required to be pretty specific, but you also want to give yourself flexibility, knowing that there might be some things that could be difficult in the future. Another common question, what if there's also a law enforcement investigation or something else that impacts the speed of an investigation? But law enforcement investigations are one I see pretty often. So you are allowed temporary delays. You can have temporary delays, and they give a couple examples in the regulations that could include absence of a party, concurrent law enforcement, securing language translation needs or accommodations for students with disabilities. Those are some reasons why it might temporarily delay a process. However, the regulations emphasize that it needs to be temporary. Temporary does not substantially extend the time limits in a process. And we'll talk a little bit more about concurrent law enforcement activity on Thursday. But what that means is you can't wait for the conclusion of a law enforcement investigation before moving forward in your process. You can give them a little bit of leeway if they want to conduct a first interview, if they need to make a pretext phone call. You can work with your law enforcement on that, but we're not going to be waiting for the conclusion of an investigation, especially if that's going to be taking a couple months. And we're definitely not going to be waiting for the conclusion of the full criminal justice process all the way until the court decision comes out. There's a lot of good reasons for that, including that our standards are different in the K through 12 system and in Title IX. But just know that those are temporary delays. So think about, for your policies, what does temporary mean for your district? What is a reasonable amount of time to have a temporary delay? And while you want to be flexible, know that doubling or tripling the length of your process is probably not going to be a temporary delay. So step 4, the decision-making process. So this is after the investigation is complete. We've wrapped that up and submitted the investigation report. So the decision-making process needs to be done by a person different than the investigator. So you have an investigator or maybe a pair of investigators conducting the investigation, then they pass it on to a different decision maker. That could be one person or a panel of people. So the decision-making process needs to be an independent review of the investigated report, all directly relevant evidence, and any party responses, again, by a person who's not the investigator. You also are required to engage in what I'm calling a modified cross-examination process. Cross-examination is directly required for higher education. It's required to be live and in person. For K through 12, that's not required. K through 12 schools are not required to hold live hearings, and they're not required to conduct live in-person cross-examination. However, they do need to do a modified form where they allow parties to submit written questions, and then they send those questions to the other parties, allow them to write a response, and then there can be limited follow-up questions. The regulations say that you can conduct this kind of modified back and forth written question process during that 10 days of reviewing the investigation report. So you can integrate that within that process. But again, you'll need to specify what that's going to look like, how long folks will have to respond, a lot of different things in your policy. There's also a note that there's some limitations on what kinds of questions. So the questions need to be directly related to the allegations, and there's some limits related to the complainant's sexual behavior. You can't ask questions about the complainant's sexual behavior except for a couple of specific instances, and those are listed in the regulations. So knowing that there's a couple of different rules of evidence, and you'll need to train decision makers on what those are so that they can appropriately screen questions before passing them on to the other party. Now, I mentioned that K through 12 schools are not required to hold live hearings, but they can do so if they choose. And they also say that you can choose to do so in some circumstances and not others. So for example, your policy might designate that live hearings will be held if both parties request them. And that way that allows you to hold live hearings if both parties say, yes, we want a live hearing, and then you can have it. You don't have to have them in other cases. So we had a question, does the modified cross-examination process fall within the investigative process, or does it occur once the investigative report is handed off to the decision maker? It's the second one. It occurs once the investigative report is handed off to the decision maker. So in that timeline, at the time once the investigative report is finalized and once it's sent to the parties, it's also sent to the decision maker. And then the decision maker could, during that 10-day window, facilitate some questions. You also could wait until the end of the 10-day window and then facilitate the questions. I think it's important that if you're doing it within the 10-day window to consider what's reasonable amount of time to have somebody review the report and all of the evidence, and to make sure they have appropriate time to think about what their questions are before you require them to submit it. So step 5 is appeal. So at the end of the decision-making process, you will issue a determination of responsibility. We'll talk about what that looks like on Thursday. And then it'll also have whether or not the person is found responsible. We use the terms responsible and not responsible in Title IX. We don't use guilty and not guilty, but it's really akin to those. So it'll show whether the person has been found responsible, what the reasoning is, and also let them know that they can appeal. So under the new regulations, schools are required to allow individuals to appeal, and that's both the complainant and the respondent, under at least 3 grounds. One is procedural irregularity. So if there was an issue, if something wasn't followed that's listed in the school's policies and procedures, they can say, hey, I think you didn't do this. I want you to look back at things. So that could be, you didn't give me enough time to review the evidence as per your policy. Another one is newly discoverable or available evidence. So let's say that they have just discovered that there's actually a video available, or a new witness has come forward and said, hey, I didn't let either of you know about this before, but actually I saw what happened. That could be newly discoverable evidence that you could appeal on. The third one is bias or conflict of interest. And the regulations are really emphatic that these processes need to be free of bias and free of conflict of interest on the part of all those participating. So your Title IX coordinators, your investigators, your decision makers need to be free from bias or conflict. So those are the 3 things that you're required to offer appeals on, and you can also designate more in your policies. You also can set time limits on the appeal, and you'll designate those. And appeals are one level. They're pretty clear that it's one appeal, and then the decision on that appeal is final. So this is going to be different from some of our processes in Oregon, where we have multiple levels of appeal. Know that for our Title IX processes, it's going to be one level of appeal. Your appeal decision maker needs to be different than your decision maker and your investigator. And your appeals decision maker, again, could be a group of people. So that could be, for example, a superintendent, a school board, other folks like that. So think about who you might want your appeals body to be. And then lastly, remedies and sanctions. So if there's a finding of responsibility, sanctions and remedies must be implemented, and those need to be described in the determination of responsibility. If they're altered in the appeal, then those would be altered a little bit in the appeal decision. Sanctions are disciplinary measures imposed on the respondent, and remedies are designed to restore educational access for the complainant. These may overlap a little bit, and remedies could also be supportive measures. And remember that other supportive measures that were implemented at the beginning may also stay in place or be further implemented for both the complainant and the respondent after a finding. One thing that's important about supportive measures and sanctions is that the regulations emphasize these need to be very different things. Sanctions and supportive measures should never overlap because supportive measures need to be non-disciplinary. So when you're writing your policies, think about what are things we might implement as sanctions, what are things we might implement as supportive measures, and remember that those need to be different. This doesn't stop you from utilizing supportive measures as a remedy, like I said, but you do need to keep those sanctions and supportive measures separate. The reason for this is that we don't want to be, again, we can't levy any kind of disciplinary action on a respondent without the result of a grievance process. And so we can't implement anything that might be seen as a sanction unless there's been a finding of responsibility. And remember that supportive measures can be implemented before a grievance process or without a grievance process even initiating. And that's a quick overview of the process from start to finish. There's a lot of intricacies, and I'm sure folks have a lot of questions. I'm happy to try to answer as many questions as I can. And again, as soon as we close the webinar, I will be sending out a PDF. I apologize for those of you that weren't able to download both of the handouts, so I'll get those to all of you. Next up, on Thursday, we have our second part of this webinar where we'll be delving more deeply into what people are involved in these, what policies need to be updated, what's the ins and outs of those policies, and then some FAQs around things like working with law enforcement and advocates, considerations for small school district, working with parents, all of those things. Also a reminder that you can contact ODE for technical assistance. This is my contact information, my phone number, as well as my email. Please don't hesitate to reach out if you have any questions. We can schedule a phone call, or if you'd like to schedule a training for your school or district. I know a lot of folks are going to be looking for training prior to these regulations, and we're going to work with as many folks as we can. I will be prioritizing districts that are working together. So if we're training multiple districts at a time, or for example, ESDs training multiple districts, if we get into a situation where we have too many training requests to accommodate, we'll prioritize those, but I will try to get as many of those answered as possible. Thank you again for joining us today. Again, I will send a copy of the handouts by email as soon as we close this out, and I'm happy to stay on for a few minutes if you have specific questions. Thank you again, and enjoy the rest of your morning. I'll see some of you on Thursday.